Maria VICIA CARULLO PADUA vs Joselito Padua GR, number 208258, April 27, 2022. Doctrine 1. In concluding that the husband was psychologically incapacitated, the following parameters, Tan-Andal guidelines, in determining what constitutes psychological incapacity. A. The psychological incapacity must be shown to have been existing at the time of the celebration of marriage. B. Caused by a durable aspect of one's personality structure, one that was formed prior to their marriage. C. Caused by a genuinely serious psychic cause. And D. Proven by clear and convincing evidence. 2. Psychological incapacity is neither a mental incapacity nor a personality disorder that must be proven through expert opinion. There must be proof, however, of the durable or enduring aspects of a person's personality, called personality structure, which manifests itself through dire acts of dysfunctionality that undermines the family. 3. Proof of these aspects of personality need not be given by an expert. Ordinary witnesses who have been present in the life of the spouses before the latter contracted marriage may testify on behaviors that they have consistently observed from the supposedly incapacitated spouse. 4. It must also be mild characterological peculiarities, mood changes, occasional emotional outbursts are still not accepted grounds that would warrant a finding of psychological incapacity under Article 36 of the Family Code. 5. Tan-Andal also modified the requirement on incurability that psychological incapacity under Article 36 of the Family Code must now be incurable, not in the medical, but in the legal sense. It must be so enduring and persistent with respect to a specific partner, and contemplates a situation where the couple's respective personality structures are so incompatible and antagonistic that the only result of the union would be the inevitable and irreparable breakdown of the marriage. A. An undeniable pattern of such persisting failure, to be a present, loving, faithful, respectful, and supportive spouse, must be established so as to demonstrate that there is indeed a psychological anomaly or incongruity in the spouse relative to the other. 6. The determination of psychological incapacity is not overly reliant on a psychological report, as long as the totality of evidence presented supports a finding of psychological incapacity. 7. We hereby reiterate our pronouncement in Molina that mere showing of irreconcilable differences and conflicting personalities, as in the present case, in no wise constitutes psychological incapacity. Sexual incompatibility is not a ground for declaration of nullity of marriage. 8. Irreconcilable differences, conflicting personalities, emotional immaturity and irresponsibility, physical abuse, habitual alcoholism, sexual infidelity or perversion, and abandonment, by themselves, also do not warrant a finding of psychological incapacity under the said article. It must be stressed that an unsatisfactory marriage is not a null and void marriage. 9. Article 36 contemplates incapacity or inability to take cognizance of and to assume basic marital obligations and not merely difficulty, refusal, or neglect in the performance of marital obligations or ill will. This incapacity consists of the following: A. A true inability to commit oneself to the essentials of marriage. B. This inability to commit oneself must refer to the essential obligations of marriage, the conjugal act, the community of life and love, the rendering of mutual help, the procreation and education of offspring. And C. The inability must be tantamount to a psychological abnormality. It contemplates downright incapacity or inability to take cognizance of and to assume the basic marital obligations. It is not enough to prove that a spouse failed to meet his responsibilities and duties as a married person. Incapacity must be so enduring and persistent with respect to a specific partner, that the only result of the union would be the inevitable and irreparable breakdown of the marriage. 10. Sexual infidelity and abandonment are not grounds for psychological incapacity, rather, they are grounds for legal separation under Article 55 of the Family Code. Facts. This case seeks to establish whether there is sufficient basis for nullity of marriage on the ground of psychological incapacity under Article 36 of the Family Code, between the marriage of petitioner Maria and respondent Joselito. According to Maria, Joselito is psychologically incapacitated to perform his marital obligations in that he exhibited excessive sexual desire and forced her to do unconventional sexual performances with him, specifically oral and anal sex. Maria also claimed that Joselito insulted her for her religious beliefs, attempted to kill her, failed to provide financial support for their son, never bothered to share household expenses, among others. During trial, Maria presented Dr. Villegas, a psychiatrist, as witness, testifying that Joselito had a personality disorder of a sexual deviant or perversion based on Maria's narrations. Further, the report mentioned Joselito's personality disorder as traceable from his childhood for having a cruel father and a very protective mother, which developed emotional confusion in him. That as a result, his sexual development failed to mature. Issues. 1. Whether or not there was sufficient basis to render their marriage void on the ground of psychological incapacity under Article 36 of the Family Code, based solely on the findings of the psychiatrist. Ruling. None. Ordinary witnesses who have been present in the spouse's lives before they contracted marriage may likewise testify on their observations as to the incapacitated spouse's behavior. What is important is that the totality of evidence is sufficient to support a finding of psychological incapacity. In this case, it should be noted that the personality evaluation report by the psychiatrist was based solely on Maria's narrations. Further, the basis of Maria's narration was only due to the contrasting behavior of Joselito's parents. Therefore, it does not give the court an intuitive understanding of Joselito's psychological state, as there was no information as to how Joselito reacted towards this situation and how it affected his overall growth. 2. Whether or not there was sufficient basis to render their marriage void on the ground of psychological incapacity under Article 36 of the Family Code, based on the totality of evidence in this case. None. Jurisprudence provides that one of the yardsticks to determine the presence of psychological incapacity is that the totality of evidence must present clear and convincing evidence to support psychological incapacity as a ground for nullity of marriage. In this case, apart from the psychological report, there is no other evidence presented to support the allegation of psychological incapacity. Therefore, petitioner Maria failed to establish clear and convincing evidence based on her total evidence presented. 3. Whether or not there was sufficient basis to render their marriage void on the ground of psychological incapacity under Article 36 of the Family Code, based on their irreconcilable differences. None. Joselito's inability to sexually satisfy his wife Maria because he prefers the unconventional way of coitus could not be taken to mean that Joselito is psychologically incapacitated. Sexual incompatibility is not a ground for declaration of nullity of marriage. 4. Whether or not there was sufficient basis to render their marriage void on the ground of psychological incapacity under Article 36 of the Family Code, based on sexual infidelity and abandonment. None. Article 36 contemplates incapability or inability to take cognizance of and to assume basic marital obligations and not merely difficulty, refusal, or neglect in the performance of marital obligations or ill will. This incapability consists of one's true inability to commit oneself to the essentials of the marriage, which consists of the essential obligations, the conjugal act, the community of life and love, rendering of mutual help, procreation and education of offspring, and that such inability must be tantamount to psychological abnormality. It is not enough that a spouse failed to meet his or her responsibilities as a married person, but such incapacity must be so enduring and persistent with respect to a specific partner, that the only result of the union would be the inevitable and irreparable breakdown of marriage.